Hi, it's Matt Murphy with C Incorporated again. We're here to do another podcast with Liller. Great people to work with OSHA lawyer type situations that we might need. And the one we're talking about today is accidents. When do we involve a lawyer in an accident? Why is it important to get that lawyer involved? And, we'll also talk about the big F, right? Fatality. So we have Chuck, Eric, and Melissa with us. So just give me a quick little bit of background about basically who you are and what you do, and we'll get rolling.
Yeah, sure. I'm Melissa Peters. I will not speak for everyone. I usually do that, and I need to stop doing that. I could see Chuck saying it in his brain. I'm a shareholder at Littler Mendelsohn, workplace safety and health specialist. I do 100% safety and health law, as do Chuck and Eric. We are probably just a handful of attorneys, part of a handful of attorneys in the country that just do 100% safety and health law. So we are true specialists. Thanks for having us here today. Matt, Chuck, Eric, want to say hi?
Hey, I'm Eric Compare. I'm of counsel with Littler. I'm part of the workplace safety team and happy to be here.
And I'm Chuck Trowbridge of counsel at Littler as well. Very happy to be here. Thanks, Matt. I also practice 100% safety and health, and in a past life, I did some workers' comp as well. So I've always kind of had experience with workplace injuries and what's going to happen after that.
That's
Gotcha.
great, Chuck. That's a good little asterisk for Chuck. I mean, we use that a lot when Chuck's on cases. It comes up a lot. So
For sure. So let's dive right into it. I just got a phone call. I'm a safety consultant, and they said, "Hey, I'm not having a good day." The first thing I say is, don't say anything else. If this is a fatality or a bad accident that we don't know if the person's going to survive, please contact your lawyer and have them contact me. Am I doing it right? And why did I do that?
I mean, there's a lot of reasons. I think you are doing it right, right? When we have a fatality, uh, the stakes are higher, right? Obviously, for obvious reasons. They're, you know, it's an emotional situation. Sometimes we forget as attorneys who deal with this stuff day in and day out. Something that's unfortunately normal for us is not normal at all for anyone. And, we are sort of primed to navigate, right? With clear heads and no emotion. Or I'm not saying we're sociopaths, but we can go in there and manage the situation when oftentimes the employer and the colleagues of the deceased employee or about to be deceased employee, if it's a severe injury and it's not going well, are able to handle things, right? We can come in and sort of take over. There's also a lot of issues with privilege that are important. We're dealing with employer admissions. We're dealing with, depending upon, findings of, serious negligence, there could be criminal allegations. So it's a very big deal. It's very serious, and we are the experts. So to get an attorney involved immediately in a fatality is the best thing that you can do. Not only, I think, for sort of the mental and emotional, right? Just knowing that your attorney is thinking about the things that, quite honestly, you probably couldn't think about at that point in time, right? As the employer or as the colleague of the deceased employee. I mean, it's like we have your back. We're thinking of the liability issues and allowing you to sort of just function and work through the details, which include talking to the family of the deceased employee, and making sure everybody's okay, like your workforce is okay and everyone's hanging in there emotionally. Eric, Chuck, I don't know if you have anything to add to that.
I mean, I'll say just to, all of that's very true. And, it is an emotional time. I'm sort of going to take it to another spot is it's a fatality. It's either high profile, it's on everyone's radar at the agency. Basically, everyone else has lawyered up or is going to. The injured employee or their family is likely going to lawyer up. You may have employees who witnessed the accident are going to, go out on leave and file claims. You're going to have the attorneys for the safety agency likely involved behind the scenes, reviewing citations and guiding and directing the inspection. You may have the criminal investigators on site. Literally everybody else has a lawyer. So in that situation, you'd be foolish not to as well.
And what protection, if any, does it give them if, Chuck, if you give me a call and say, hey, I want you to put this on all your notes. I usually get a little thing that I have to write on the bottom of all my notes. I can't remember exactly what it is, but it's basically in anticipation of litigation.
Yeah.
And how do they get a certain amount of protection from you directing how my investigation goes versus how the client directs it?
So there are privileged communication. Once the company retains us, we are their lawyer. Any communication that we are being part of, we can say those are privileged. So when OSHA starts requesting documents, or more so if it goes to litigation and you have an attorney involved and they issue discovery, they'll be asking you for various documents. If those have been protected properly by the attorney-client privilege, we can withhold those. So what that means is that we kind of have a free avenue to discuss our concerns, discuss, what happened, how we are going to address it, all while having that comfort of knowing that these discussions, these emails, these documents that we produced or that we prepared are going to stay, in this circle of trust.
Yeah. And I mean, the origin of the privilege, right, is you have to, in order to do your job as an attorney, you have to be able to keep it real, right? Have the real talk with your client. And nobody is going to want to do that. Your client is not going to want to keep it real with you if they think, everything that they're telling you is going to get them into trouble. So it's this idea that it doesn't have a chilling effect sort of on the truth, right? That's where the privilege sort of stems from, right? So in order for us to do our jobs, we have to drill down on the good, the bad, and the ugly, right? And, once we're involved, if we direct the work, like you were saying, in it, creating an anticipation of litigation, if we start directing work, that is something that we can protect completely, right? We can't always protect, things in the past, right? So that's where it gets a little dicey. But if you retain an attorney and work is done, or if you want to do a root cause analysis is done at the direction of counsel, right? Or certain other things are done at the direction of counsel, that is something, this little protective cloak that we can put over it. Yeah.
And to Melissa's point a little bit, and Matt, what you had said earlier, if one of your clients emails you the day of an accident and says, hey, somebody fell off a roof, we knew he wasn't wearing his fall protection, but we let him up there anyway, OSHA can, or the attorneys, that will be discoverable, and that's going to be very bad news for the client. If you have an attorney involved, you can still have those same communications, but that's not going to go to OSHA. That's not going to go to their attorney. That's going to be privileged.
And I think that's an important part for clients and for anybody who listens to this podcast to understand that, there's certain protections and thoughts and plans that you have to have ahead of time. Nobody ever thinks there's going to be a fatality. Nobody ever thinks it's going to happen to them. If they did, they wouldn't come to work that day. But it does, unfortunately, happen. And then, you're kind of stuck behind the 8 ball, right? So we've had the accident. Now we've got OSHA coming up, or we've called OSHA, right? We've got 8 hours on a case of a fatality by the time we find out, or 24 hours for a hospitalization, amputation, loss of an eye, to contact OSHA ourselves. As we talked before, that the local EMS and 911, police, et cetera, may be, depending on where you're at, calling OSHA, as they get the call, et cetera. So I think some of this stuff, it will be repetitive from our other podcast as far as inspections. But again, what are some of the things that we can expect OSHA to ask for that we should hand over? And what are some things that we should get the lawyer involved before we hand over certain privileged information to OSHA that they'll request?
Yeah, I mean, I think the first thing they're going to ask, Chuck, I'm just going to say this one thing and hand it over to you, is, if you have a fatality, one of the first things they're going to ask for, right, is the training records of the injured employee. They want to see any safety programs related to the task that was being performed and whether or not that employee was trained to do what he was doing, right? So those are going to be things that definitely need to be reviewed by counsel, simply because oftentimes there are additional things in there, right? Or things that we see that may not necessarily be responsive to the ask that we can exclude. Chuck, go ahead.
I was going to say as well, with fatalities, 10 times out of 10, OSHA is going to be there that same day. With accidents, you might have a little bit of time between when the accident happened and when OSHA actually shows up, and you can use that time to get these documents in order. They're always going to request your injury logs, your 300 logs. Make sure those are all up to date. Make sure they're accurate. Make sure everything that's in there is appropriate. You can get those documents ready ahead of time, because even if you've never had an OSHA inspection at your work site before, if you've had a serious accident that occurred there, they're going to show up. We're seeing a lot more funding to the agency. We've seen them be a lot more active. So we have had many clients that are calling us and saying, hey, this is the first time OSHA's ever been here. What do we do? We're seeing that happen a lot more often.
That's perfect. And I think instead of going all the way back through our OSHA inspection, we already did that on a podcast. They can jump on that and check that part out. So how to handle with OSHA, jump over and check our other podcast out there. Dealing with accidents, not all of them are fatalities, obviously. There's a lot more that are maybe, not what we think is going to be so big, but end up being a little bit bigger. Or maybe it's something that's going to cause a permanent percentage of a disability, etc. What are some warning flags that we need to look for and get that lawyer activated on those cases? Not everybody at once.
I mean, I think anytime you have, if you're dealing with anything ultra hazardous or, things like burns, chemicals, anything that could progress to something beyond what it is, right? Even if we're talking about amputations, oftentimes the extent of the injury is not known at the time of the accident. And there's a huge likelihood that it's going to progress, right? And that the employee's, physical health and their status is going to decline. So I think, one of the things, that's super important when it comes to an amputation, is to really try to get an assessment of how bad the injury is, right? Of course, it's easier said than done. The primary concern is getting the employee the medical care that they need, getting them transported, etc. But to the extent you can do any sort of information gleaning initially at that point in time, right? It's going to be helpful, because something we see a lot is, an employee's raced away by the EMT, and, maybe there's a witness to what happened, but nobody really knows what happened. And someone's like, well, I think their hand got stuck, but I didn't see an amputation. Well, I mean, it's possible that all the bones in their hand are completely crushed and only being held together, by the flesh, right? It could be, you have no idea what's going on under there, right? We see this all the time. And then, of course, that triggers, different responsibilities, right? Is the employee treated in the ER? Are they admitted? How extensive is the injury? And, it sounds very clinical and cold to be saying this stuff now, but all of that is gonna, be important later in terms of the timeline. And when did you know how bad it was? When did you call OSHA? Did you call OSHA? Why didn't you? Right? So it all goes back to this planning thing, right? Like when we're saying when OSHA shows up on site, like our last podcast, have a plan. Same thing here. Like when the crap hits the fan and someone gets seriously injured, what's the protocol, right? Who's going to be responsible for that stuff at the facility? There has to be a game plan. There has to be an emergency action plan. There has to be an emergency medical plan in place, right? Like who's calling 911? Who's going to attend to the employee, make sure they're okay and not getting worse, right? Who's going to go with the employee to the hospital to make sure that they're okay? Like you have to have that stuff thought out in advance, because it's an emergency, right? And we all know what happens in an emergency. Like some people are really good and cool-headed. Other people completely, lose it. They can't think clearly. They can't make decisions. They can't give direction. So if you have a plan that you can default to in those emergency situations, that's going to put you in the best position to be in a place to succeed, right? And check all these boxes, do what you're supposed to be doing.
And then in terms of like red flags, you know, obviously every accident's different, right? But like, you know, if this has happened before, even if that wasn't a citation, or if, you know, this occurred on some machine that, you know, that 3 people have complained about, you know, there are certain, you know, when you're feel the event has occurred and you've all been on notice to the hazard, that's probably an accident, even if, you know, if we're just talking a tip of a finger, which isn't, you know, still an amputation, you're still going to have to report. But if you're looking at that kind of scenario, you know, those would sort of be factors to pick up the phone and get the attorney involved, right? Because, you know, those can sort of lead to higher penalties and sort of a broader inspection. So, you know, if it's truly this one-off thing, you know, you can assess the situation, but to the extent, you know, you start to know, oh, you know, he complained about that last week.
Yep.
Oh, once you start to get there, you start to sort of militate towards picking up the phone and calling someone.
Yeah.
And these are probably part of the things that, you know, you want to incorporate in the plans Melissa's talking about, right? You want to really assess the situation, not necessarily write all this down. He told me yesterday, but, you know, someone got to be mindful of, you know, is this really sort of a one-off surprise? If it's not, you need to pick up the phone.
Perfect. And to Eric's point, something else to keep in mind, why it may make sense to bring in lawyers, you know, the first time this happens is, you know, employers going to be dealing with the possibility of repeat citations in the future. So if you have an employee who is injured using a machine that all of your employees in the facility use every day, or you have the same machine being used at your other facilities, you know, throughout the state, throughout the country, you can be looking at the possibility of a repeat citation if someone gets injured doing, you know, a very similar activity or the same activity on that machine. And the consequences of a repeat citation from a financial standpoint are far more serious, far more severe. Serious citation, the maximum penalty is a little over $15,000. For a repeat citation, the maximum penalty is over $150,000. So if you can do your best at the outset, if you have a citation related to a process or a machine that everyone is using, to minimize that citation or even ticket and get it vacated, you know, it's really in your best interest to bring in the people who can help you do that as early as possible.
That's great points. Great points all around. Another item that I'd like you guys to touch on maybe is back in the day, we always talked about having one person deal with communication to the press, which was great when we had press. Now everybody with a cell phone becoming a reporter. Maybe talk a little bit about that and how that complicates the situation out on a job site. I was unfortunately the worst I saw. I'll just say, I think it was 2 years ago, there was a fatality. Everybody on the job site had their cell phone out all over every level trying to video, you know, this poor scene, which was terrible. But I'll throw that to, you know, Chuck, Eric, and Melissa.
It's funny. We're doing this. We have this conference, this legal conference in a month, and Eric and Chuck and I are part of a presentation panel, and we're doing this little vignette, and that's part of it, right? Like another employee is videoing, right? What's going on? I mean, there are, you know, I guess I don't want to go too deep on sort of like privacy and stuff, but you know, certainly if things are occurring at a facility or inside, and there are, you know, machines or processes that are protected, right? There can be sort of a blanket, certainly in terms of when you're producing information, videos, documents, and such to OSHA, right? Because anything that you produce is essentially open for Freedom of Information Act requests, right? Or I think we called them something different in California, a Public Information Act request or something like that. And, you can try to limit things to the scope possible, saying it's proprietary or confidential, right? So OSHA has a right to see this stuff, but they can't reproduce it to the general public. It's much in the same way. Like, I mean, if, there's privacy rights involved, right? Especially if somebody's dying. And I think, a way to get ahead of that is to have these conversations with your employees, right? I mean, a lot of employers don't allow cell phones on facility floors for safety reasons, right? And I understand that when something, it's a stop work situation, because someone's been hurt, people can bust out their cell phones. But again, if you can make that part of your plan and say, listen, no one is to be in this perimeter and no one is allowed to use their cell phone, right? Out of respect for the individual. And I mean, I think that's just like a ethical and good and moral thing to do, right? For this person, for their family. But also, I'm a lawyer, so it's from a liability perspective that we're giving this advice too, right? You want to do what you can to try to limit any sort of leaks, or control the narrative, so to speak, right? The information that OSHA gets its hands on, you want to be the one giving it to them. So if you can tell the employees, this is not allowed, this is not going to happen, this is a company rule, put your phone away, I think that would be the cleanest way to deal with it. Eric or Chuck, I don't know if you have thoughts on that.
I think also if you do have employees who are being contacted by the media, by the press about the incident, we have many clients that send out a notification to all their employees saying, hey, if you're contacted by the media about this, direct that person from the media to so-and-so at the company. Figure out who your person is going to be, who's going to be the spokesperson to the media, and direct any of your employees who get those contacts to send along their contact information. And as you had, Matt, as you had referenced in that one fatality you had, I think employers well within their rights to restrict access to the area. If you have a lot of employees there who are doing something like that, trying to take videos of the incident, pull them all back, get them out of there. They have no need to be there at that point. You need to make sure the scene, not just from your OSHA perspective, but I'm sure the police are going to be investigating. You need to make sure that scene is secured. You can certainly pull your employees back from there.
Very good. And interviews, what do we need to know about interviews? Because obviously they're going to want to interview about everybody in this situation. Is it good to just conduct your interview out in the middle of everybody, or what's the importance of singling out interviews, and maybe even touch on written witness statements, if you don't mind?
Yeah. Singling out interviews is important because you want to make sure that everybody's being honest. Like if Melissa and Eric watched Chuck die, sorry, Chuck, and then Melissa's talking to the OSHA inspector with an earshot of Eric, and we were all friends. Eric's version of what happened might be influenced by what he hears me tell the inspector, right? We all know that as time passes, memories fade, right? And certainly in a situation where there's trauma or shock, or something really terrible happens, everyone can have a different version of the story. But I think it's really important to separate people before they start talking. Don't allow them to overhear what other people are saying. In that way, you can sort of cross-check the information that you get, right? Well, Melissa said this and Eric said this, and these parts of the stories line up, and they didn't hear each other talking, so we can assume that this is accurate, right? I mean, that's going to give you sort of like information that you need. Certainly. I don't know, Chuck, Eric, I sometimes I get sick of hearing myself talk, so I'm going to let somebody else jump in here.
And Matt, to your point about written statements, a lot of our clients, as soon as the accident happens, they want everyone to record what happened, what they saw, where they were, etc. Keep in mind what we talked about earlier. If they're doing that without legal counsel involved, if they're just conducting their own safety investigation, all that information, those written statements could be discoverable later on. If you bring in an attorney early on and have that investigation performed at the direction of counsel, you can arguably claim that all of those written statements are privileged, and therefore, you're going to be keeping those in that circle of trust we had talked about earlier.
That's a very important part. And it doesn't mean you have to have the lawyer there directing, right? You can make the phone call, get a hold of you, Chuck, or Melissa, or Eric, and say, hey, this is what happened. We're getting ready to do interview process, and let you handle how that goes about, kind of quarterback it from there.
Exactly.
What's the difference?
And one thing, Matt, in that regard, if you have your lawyer, involved in the investigation, what this employee says to me is, I'm not in an attorney-client relationship with them, but my notes are work product. And one strategy you can have to appease certain workplace agencies is you can sort of, I don't want to say commandeer the witness statement process, but, you can, help direct the witness statement so they're just purely factual in a way that's not undermining, to your positions. And then you can actually supply those to the agency in a sort of good faith show that we are, doing our investigation, and that the rest of it is under counsel and being not completed. And sometimes I find in particularly serious accidents, that sort of middle ground will get the agency off your back with regard to the actual any further documentation of an inspection. So you can sometimes use the witness statement strategically.
And would you suggest that witnesses sign their statements and write their statements, or does it matter if somebody writes it for them and there's no signature?
I mean, as long as it's credible, right? I mean, if you have someone who barely speaks English, signing something, that can be problematic, right? So, I mean, it varies.
Okay.
Sometimes it's best to have them write it. Sometimes you can type it. That's just going to vary from situation to situation. It's going to come down to when this is presented to the witness, are they going to say, yeah, I read it and understood it and signed it? Or is it better for them just to say it in their own words, even if not necessarily perfect? But you just want to keep them factual, right? This isn't a time to be asking them why they thought something happened. To the extent you're going to do them, it's got to be very clear, I just, what did you see and hear? And, to the extent that those can be created, I'm not saying everyone should run out and do them. I'm just saying that sometimes they can be used effectively in an inspection.
Very good. And to Chuck's point, finding out where they were at the time of accident, I usually ask, if I'm getting ready to do a witness statement, can you take me to exactly where you were at the time of the accident, what you saw, and from what your view was? Because they have great, visual stories that they let you know what happened, and they were in the parking lot 300 yards away and couldn't see a thing, but they heard it enough, by the time you got there. So that's really where we're going to be with this. I'm going to ask Chuck, Eric, and Melissa, hopefully in that order, to just give me kind of maybe a helpful hint or something to think about, putting my plan of action into place for accident investigation, or, maybe just tell us something to stay away from. But just your part to add in your last thoughts to this.
Yeah, I think it's what I would emphasize is always be prepared. Know this is going to happen. As we talked about earlier, we're seeing a lot more activity from OSHA. So even if you've never had an OSHA inspection at your work site before, if you've had a serious accident, it is very, very likely they're going to show up. So don't think, or don't be surprised when they do. Make sure you have your plan ready and in place.
Very good. Eric?
Yeah, I just resist the urge to jump to conclusions. Don't, decide in your mind what happened. Just, lawyer it up or not, you're just taking the facts. There's no obligation for you to have, some cause and effect analysis in place, hours or even days after the event. Take your time and, let things play out.
That's great advice. I can tell you I was on one this week, and the state OSHA was involved in the whole 9 yards, and they're coming up, everybody's got scenarios. And I said, well, the person didn't pass away. The only person who knows exactly what happened is in the hospital. We can talk to them and find out. And it was very different than anybody cooked up in their brain. I can tell you that. Melissa?
Yeah, I would just say that, going back to sort of the human element of it, the employees that are at the site and still working and still coming to work every day. They want to see that they're working somewhere where they're valued and safety is important, right? So I think it's really critical to communicate to the employee population, to be, sympathetic and to provide support. Everybody deals with this stuff differently. We all know that, employees that are unhappy are more likely to pick up the phone and call OSHA, or more likely to call up that inspector who left his number and start talking, right? So you want to remind the employees that you're there for them. You want to communicate that, if the employee has passed away, that you are, talking to the family and you are going to make resources available, I don't know, or managers available to talk to individuals who have concerns or want to talk or anything, right? Like, I mean, it's just really important to continue to be human, I think, in these situations as well. I think that goes a long way in sort of giving confidence and reassurance to the other employees, right? That their employer does care about them and they cared about this person who was hurt or died. And, that means a lot, right? That goes a long way.
That's very important. And one thing that I tell everybody when they do that plan is if it's a bad accident or a fatality, make sure you get counseling involved.
Yeah.
You don't just say, here's the number. I always give them my trick of the trade, which is I'll go, hey, Melissa, Eric looks a little tore up about this. Could you call this number, kind of tell him what you saw so Eric doesn't have to relive the whole thing again? And, I think that would help him out. Melissa says, sure. Then I walk over to Eric and I go, hey, Eric, Melissa looks a little tore up about this. Can you call this number and talk to him and kind of pave the way for her? And, oh, by the way, Chuck, can you make this phone call for me? And it's more like you're doing me a favor. And a lot of them will come back and go, man, I'm so glad I made that call. It wasn't just about Chuck or Eric. Man, it really tore me up on the inside. And, they really helped me through that. And to your point, Melissa, it makes them feel like everybody cares, because they do. I mean, that I tell everybody, you've got 2 weeks. You got a bad accident or OSHA showed up, you have 2 weeks to make the biggest impact, because unfortunately the machine starts to catch up to speed again.
Sure.
And you start to lose that power, that spot. So get your training done, nail it home, make sure this never happens again, right? I can't thank you all enough for giving me the time to do this podcast. Again, we love working with these people at Lillard. They're top of what they do. We work with a lot of different firms, but it's a one size fits all, as in I can make a phone call and they'll have the right lawyer contact that person for my clients. So that's why I wanted to have them on, and they're extremely knowledgeable, which you saw, and they're not the boring lawyers that you sit across from and go, oh my God, I'm paying much for this. So they actually have personality. So that's why we use them, and that's why we have them on the podcast. So again, I greatly appreciate it, everybody.
Thanks, Matt.
All right, thanks, Matt.
Hopefully you enjoyed that, and you'll check out our podcast on seeinkonline.com. Thank you very much.